In an unprecedented move, the New York Times has initiated a lawsuit against tech giants OpenAI and Microsoft, citing the unlawful use of their copyrighted articles to train sophisticated chatbots. The action marks a critical juncture in the evolving relationship between traditional media houses and the technology sector, signaling a tough stand on intellectual property rights in the age of artificial intelligence. The lawsuit claims that millions of the New York Times articles were ingested by the training algorithms of AI chatbots, enabling these digital entities to produce content that directly competes with the original publisher. The case underscores the tension between the explosive growth of AI capabilities and the imperative to uphold the sanctity of copyrighted material. This lawsuit arrives at a moment when media organizations are grappling with the challenge of maintaining their hold on content creation amid the rising tide of AI-driven platforms. The ability of AI systems to analyze and replicate human-written content has fueled concerns about copyright infringement and the long-term implications for content creators. The New York Times, long revered for its quality journalism, is now leading the charge in this legal confrontation, which could set a precedent for how machine learning technologies access and utilize copyrighted materials. At the core of this dispute is the question of fair use and the balance between fostering innovation and protecting the rights of authors and publishers. The breach of copyright claimed by the New York Times is not only a corporate issue, but also one that affects journalists, authors, and creators worldwide who rely on copyright laws to earn a living from their work. With this lawsuit, the venerable institution is fighting for the rights of content creators everywhere, asserting that automated systems should not undermine the legal protections afforded to intellectual property. As chatbots become increasingly adept at generating human-like text, the outcome of this case is poised to have far-reaching consequences for future interactions between AI developers and content creators. The battle lines are drawn, and the legal community, tech industry, and content producers are watching closely. The resolution of this lawsuit could potentially redefine the boundaries of copyright in the digital age, testing the limits of what is permissible in the training of AI, and ensuring that innovation does not thrive at the expense of copyrighted work. The significance of the New York Times action cannot be overstated. If the courts rule in favor of the publishing giant, the decision could prompt a radical reevaluation of how training data is curated for AI development. Conversely, a ruling favoring OpenAI and Microsoft could pave the way for a more liberal interpretation of copyright law, allowing for broader use of existing works in the push towards further AI advancements. As society stands on the precipice of a new technological era, the verdict in this case will undoubtedly influence the future course of AI development and the protection of intellectual property. The world awaits a legal clarification that will have a lasting impact on both technology and the age-old principles governing the rights of creators.